Good day. Today we're going to be dealing with Chapter 5 of the lawmaking process in Zimbabwe. So we're going to look at the different organs on the state that influence the lawmaking process in Zimbabwe. We're going to deal with the pre-bill stage, the gazetting of bills, the types of bills, what happens when the bills get into Parliament, which is the passage of bills, as well as delegated legislation. Now, in terms of state organs, we have the legislature, right, which has the primary function of making laws in Zimbabwe. Legislature consists of the parliament as well as the president. Now, the parliament consists of two chambers. We have the House of Assembly, which is the lower house, and then we have the Senate. Now, the laws that they make go through two stages. They must be passed by the required majority of both houses, and they must be ascended by the president. We're going to deal with that later. So this is the legislature as a state organ. Now, the executive, this is the arm of the government that implements the laws. It executes the laws, as the name suggests. And the legislature consists of the president, the cabinet, law enforcement agents like the police, the military, the prison services, but primarily the executive powers are in the president. Now, the president is elected for a 5-year term, and the terms, however, are not limited. So he can get into the presidency and sit there for 5 years and then decide to get re-elected 10 or 20 times, as long as the people will it. Now, in terms of presidential powers, we are looking at the authority that the president have. We have the power to appoint and dismiss vice presidents. We have the power to appoint provincial governors, to declare war, to enter into international treaties, and so forth, as is authoritated by the Constitution. Judiciary is the organ that interprets the law that we're going to be talking about. It looks also at the constitutionality of the legislation, and whether it is consistent with the Constitution or not. If it is not, it invalidates that legislation. It is one of the cornerstones of the separation of powers, because it's required to be independent, and it ensures that the law is adhered to by the other two organs. Now, besides the three main state organs that we talked about, there are also other key organs that also assist to enforce the law and so forth. We have the Attorney General's office, which in Zimbabwe is subdivided to the Prosecutor General as well as the Attorney General. Now, the Attorney General is the legal advisor to the state. The Prosecutor General represents the state in criminal cases, represents the government. And then we have the Auditor General's office. It is the office that examines or audits all government accounts at least once a year, and is required to report to the president all the findings that are found. And in doing so, it obviously has to be independent in the discharge of its duties. And then lastly, the Zimbabwe Human Rights Commission, which was once the Public Protector's Office. This one is a public office that helps the legal persons of Zimbabwe. The purpose is to investigate any complaints by the members of the public against any government departments or statutory corporations. Now, an actual lawmaking process in Zimbabwe. The Constitution provides the power of the Parliament to make laws, and it shall be exercised by passing bills in the House of Assembly, in the House of the Senate, and ascended by the President. The procedures for passing of the bills in terms of Schedule 4 of the Constitution, as well as the standing orders as mandated in terms of Section 139. Now, if Parliament attempts to pass a bill contrary to the procedures that are laid down in the Constitution, then their conduct would be invalidated. We'll talk about that one later. Now, the pre-bill stage, before a bill makes it into the halls of the Parliament, into the sacred halls of the Parliament, it has to go through a pre-bill stage. The stage leading out to the finalization of proposals that are going to be laid out in Parliament. The legislative proposals are as a result of various things. They come from political party manifestos, government departments, commission of inquiries, parliamentary portfolio committees. They lay out the proposals that are there. Unlike other governments, however, ours does not make public consultations a requirement. Consultations are carried out at the government's discretion, but they are also noted in terms of standing orders. So it is it is encouraged for public consultations to be done. Now, we have the process of proposals. So this is the pre-bill stage. First, we have cabinet ministers. They make public policy decisions to make laws. They decide, this government department requires a new law that regulates this and this and this and this. When they make that decision, they submit the decision to the relevant government departments through the relevant ministers. And that decision includes the detailed principles of the proposed legislation. They would say, this is what we want that legislation to reflect. So after that, the principles are set out and sent to the Cabinet Committee on Legislation, whose function is to debate and approve the principles in light of the full cabinet policies, right? When they continue on, the principles are then later sent to the Attorney General's office for drafting by the designated person, consulting with the relevant government department that deals with those proposals that they'll be laying out. So if they are proposing a change in taxes, they'll talk to the Minister of Finance. So later on, the draft bill that is made in the Attorney General's office is then later on sent back to the committee, the Cabinet Committee on Legislation, with any accompanying memorandum which must scrutinize the bill in light of the policies laid out by the full cabinet in the beginning. Now, after approval by the CCL, the bill is sent to the full cabinet in the case of important bills or controversy in the bills, or it is then later on sent to Parliament if the CCL mandates to do so. Now, the types of bills that are there, we have public bills which attempt to alter general law and deals with generally the administration of justice, and then we have private bills that deal with matters of a private or local nature, like legislation promoted by local authorities. And then in terms of bills, there is a process of the gazetting of bills. Gazetting of bills, we are just saying the publicizing of bills. How do we do that? Through the Government Gazette, which is the official legal medium for legal instruments. This is the same in most jurisdictions in different states. Now, the Constitution does not require a bill to be gazetted except for constitutional bills for 30 days. However, in terms of standing orders, they require that bills should be gazetted 14 days before its introduction into Parliament. Now, this requirement may be waived in the cases of emergencies, and I gave an example in class, and I was talking about during the time of COVID-19. Imagine if we had to gazette a bill that related to COVID-19, and then that would um, that would that would delay the whole process, and while least the COVID-19 infections would be spreading. So in matters of agency, the gazetting of bills may be waived. Now, the passage of bill in Parliament. This is when the bill now make it into the halls of Parliament to be voted on and so forth. So it is important to note that if a bill is introduced in the House of Assembly, it must finish this whole process that we are going to talk about in the House of Assembly, and then later on refer to the other house, which is the Senate. But if it is initially started in the Senate, it goes through this whole process in the Senate, and then it is later on submitted into the House of Assembly to be voted on. Now, let's continue. The first stage, this is the first reading of the bill. A member responsible for the bill must serve the notice of intention that leave be granted by the House to bring the bill, right? And then the member must bring a copy of the bill, and the clerk of the bill reads the title of the bill, right? So the first stage, we're just dealing with bringing a copy of the bill to Parliament and reading the title of the bill. And then later on, we've gone off to the Parliamentary Legal Committee. In the Parliamentary Legal Committee, this refers to the committee that examines the bill or statutory instruments and determines whether they are in conformity with the Bill of Rights and other provisions of the Constitution. Now, as we continue passing the bill in Parliament, we have stage 3, which is the second reading. In the second reading, now we are not we are done with the title in the first reading, right? So in terms of stage 3, in the second reading, we are now looking at the purpose of the bill. We read out the purpose of the bill and the principles upon which it is based, and then the PPC present its reports on the bill. It scrutinizes the proposed bill, and it provides public hearings and presenting a report to the Parliament for such public hearings. Now, we've gone off to the stage 4, which is consideration by the committee. The bill is considered clause by clause by the committee of the whole House. Amendments are proposed and debated. The chair of the deputy speaker and the PPC amendment proposals are also discussed. Now, on stage 5, we have the reporting of the bill, making an amended report of the bill to the whole House, because on the previous stage we were criticizing the bill, making amendments to it and so forth. Now we are reporting those amendments to the whole House. It is mere formality if subject to prior of the committee of the whole House. So it is a mere formality because in the previous stage it was the whole House that was doing all those amendments and so forth. So in this stage we are merely reporting everything that we all have been doing. So it is a mere requirement, the committee of the whole House. So in terms of stage 6, we are referring back the bill to the PLC for scrutinizing once again, because the first scrutinization by the PLC, right, did not include the amendments that have been made at the stage 4 and 5. So we are now re-scrutinizing it again in the Parliamentary Legal Committee portfolio, and then we are relooking everything, right? And then stage 7, that's when we have the third reading, which is wherein we vote for approval or rejection of the bill. Now we look at the quorum of the House, wherein the majority of those that are present, right, when it's a normal bill, right, in terms of a normal bill, the majority of those that are present should vote in favor for a bill to pass on. If the majority do not vote, or the majority vote in disapproval, then it does not continue, it is done. But if they vote in favor, the bill continues off to the next stage. In terms of the constitutional bill, it is different because of the supremacy of the Constitution. 2/3 of the majority from the total membership must vote in favor for it to continue on. Now, stage 8, this is the transmission to the other house. We talked about this on the first instance. When a bill is been initiated in the House of Assembly, it now goes off to the Senate. If it is initiated in the Senate, it now goes off to the House of Assembly. The other house may reject or pass it, or with or without amendments. Disagreements are dealt with in terms of paragraph 3, subsection is paragraph 3, schedule 4 of the Constitution. And then we have the resolution to either agree or disagree with amendments that are sent via message. And then lastly, we have the presidential assent. A bill only becomes law when it has been ascended by the president. In terms of the Constitution, the bill has to be accompanied by certificates from the Speaker or President of the Senate. And then when the President does approve the bill, then assents and it becomes law. But it does not approve the bill, it then sends it back to Parliament. The Parliament can then later decide no. If the President has not refused to assent, then leaves it, or if they still insist, they send it back again to the President, who then later sends it to the Constitutional Court, who decides on the constitutionality of it. If the court decides it is constitutional, the bill then becomes law. If it decides it is unconstitutional, then the bill is repealed. It does not become law. Now, this whole procedure that we talked about, failure to do this whole procedure, it means that the bill would be nullified. It would be invalidated by the Constitutional Court because the relevant procedures have not been done. The conduct was unconstitutional. So this has been dealt with in the MDC case versus Minister of Justice, Legal and Parliamentary Affairs. We know the facts of the case and the reason for the judgment are laid out clearly in your notes. Read up on them. If you have any questions, just send them via email and I will discuss it with you. Now, in terms of delegated legislation, we noted that Parliament may delegate lawmaking process to other public authorities, and then this whole aspect of delegating legislation is recognized in terms of Section 134 of the Constitution. The enabling act that authorizes another public official to make legislation confers such powers to those public officials, and then they delegate the powers, and delegated legislation is enacted. Now, the delegation of legislation dances on the line of separation of powers, because in terms of separation of powers, we are saying that each branch has to have its own functions and separate from any other branches. Now, if the Parliament is able to delegate legislation to the executive, legislative powers to the executive, then it becomes an anomaly in terms of the whole aspect of checks and balances and the separation of powers. But there are substantive and procedural safeguards that have been put in place to ensure that the principle of separation of powers still remains intact despite such delegated legislation. The substantive safeguards are that the delegated legislation must be consistent with the parent act. It must be consistent with the Constitution. Otherwise, it would be ultra-vires and would not be valid. Now, the procedural safeguards are that some statutes require the statutory instrument to be laid before the Parliament, right? Before it is even enacted. And then the PLC is also required to examine every statutory instrument to determine if it is inconsistent with the Constitution. So these are the procedural safeguards that are there to ensure that there's still some checks and balances that are there, despite the conferring of legislative powers. So the benefits of such delegated legislation is pressure on parliamentary time. The parliament has so much on their hands that they have to make laws that are in terms with the changing values of the community and so forth. So the delegated legislation, because to ensure that legislation still is in keeping with the times and they are not in too much pressure, ease of difficulty of administrative details before bill is introduced, so to ease the role of the parliament and also to deal with any emergency situation. They can now deal with emergency situation because they would have the actual time to do so. So they would delegate legislative powers and deal with emergency situations that would be there. So on the previous slide that I skipped, it was the advantages and disadvantages of delegated legislation and straightforward stuff. So thank you for listening to our presentation. We'll see you in our next class. This was the lawmaking process in Zimbabwe as laid out by Maduku with an amendments to contemporary new legislation therein.